All right, I have 4 o'clock. Are we ready to start? Staff's good. All right. Welcome to the regular meeting of the Davenport Zoning Board of Adjustments. It's 14 April 2022. The Zoning Board of Adjustment hears requests on hardship variances to the rules in place by the city zoning laws, special use permits, and we rule on appeals to administrative decisions and interpretations. If you have a mobile device, please place in silent mode so we are not disrupted during the meeting. I am Dan Darlin, Chairman of the Davenport Zoning Board of Adjustments. Members present today from your left to right are James Reistroffer, Bridget Boyd Carlson, myself, Tom Quinn, and Angela Labach. Staff present, Laura Berkeley, Scott Coops, and Tom Warner, counsel. As we conduct our business, we expect everyone here will conduct themselves in a respectful, courteous, and civil manner and will speak only after being recognized by the chair. The sole exception to this standard is staff is expected to interject when necessary to ensure we are properly conducting our business. If you wish to speak on a particular agenda item, you will be provided an opportunity to do so when you've been recognized by myself. When you're recognized, please come to the podium, introduce yourself each time if there's more than one occurrence, and tell us what you want us to know and to consider. Whether anyone is allowed to speak more than once is at my discretion. So the first thing we need to do is approve the minutes from the March 24th Zoning Board of Adjustment meeting. So are there any questions or concerns about that? And if not, I will entertain a motion to approve.
I will make that.
All right.
I'll second.
Okay, then we just need a voice vote. All in favor?
Aye.
Aye. Anyone against? Nope. All right. We have old business, so reconsideration of request AA22-01 of Mike Malloy on behalf of John Davis, and the business is Alley Cats LLC, for an appeal of an administrative interpretation, appealing the zoning administrator's interpretation letter dated December 9th, 2021, regarding sale of vehicles at 1707 West River Drive in the city of Davenport, Iowa. Property is zoned I-2 Heavy Industrial District, and it is in Ward 3. At our last meeting, a motion was made to reconsider this item, and that motion was made by a member who voted in the prevailing or on the prevailing side, and it was seconded and adopted. The effect of an approved motion to reconsider puts the consideration immediately back on the board in the exact position it occupied at the moment before it was originally voted on. Thus, the board will not be taking additional evidence or comments. If, however, a board member would like to have further discussion or to further discuss this item with other members of the board or has questions about the agenda item, the member may ask his or her question to the applicant or staff. Responses should be limited to answer the board member's specific question. All points from the previous board meetings are captured and approved in the minutes and are available to the members. So that is to say, everything that's already been discussed we have on record, so it doesn't need to be, that doesn't need to be rehashed. So we're at the point where in the other meetings where everyone's done giving their case, staff reports, everything else, that it then becomes the board's turn to discuss and make a decision. So since the board's asked to reconsider it, that's the point where we're at. Sure.
My name is Michael Malloy. I'm an attorney representing John Davis and Alley Cats LLC Back on March 10th, we presented the case and the evidence to you, and the board approved this request to allow the sale of vehicles at 1707 West River Drive, Davenport, overturning the staff's interpretation. After approximately a 2-hour meeting, and after we submitted to the board 11 exhibits in support of our position, the board voted 4-1 and made a final decision on this case. On March 24th, 2022, the board moved to reconsider their March 10th vote in favor of my clients without any legal basis to do so. The board could not legally reconsider their prior approval of the March 10th vote at the March 24th, 2022 meeting. First of all, the board has not adopted Robert's Rules of Order, as the city attorney advised you at last meeting. Secondly, the board has not adopted any rules of procedure allowing a motion to reconsider at a subsequent board meeting. Even under Robert's Rules of Order, a motion to reconsider is required to be made at the meeting that the board originally voted in favor of said motion. In this case, that motion to reconsider would have needed to be made at the March 10th, 2022 meeting. Therefore, if you go forward today, you are violating my client's due process rights. In short, you cannot lawfully take up a motion to reconsider in this case today. You have already made a final decision like you do at any other board meeting, and you have not followed any written rules of procedure regarding motions to reconsider. Secondly, I didn't even get a notice as the attorney for John Davis or Alley Katz that this was going to be heard today. My client should have gotten some kind of written notice from the city of Davenport regarding this matter. I found out by looking at the board agenda that was posted, I believe, yesterday for today's meeting. In short, we contend that you're violating your own rules of procedure and you should not vote to reconsider this motion. If you decide to move forward to reconsider the merits today, you will be violating your own rules of procedure as well as my client's real property rights. Thank you.
Thank you. So council can step in if needed, but my understanding is that until the minutes are approved at the next ZBA meeting, that it's not final until that point. And at that meeting, a prevailing member of the board motion to reconsider, which is the process. So is that tracking?
Yes, motions to reconsider may be made at the meeting in which the vote was originally taken or at the next regular meeting. Anytime thereafter, it would not be a valid motion to make.
Right, so it's not final until the minutes are approved at the subsequent meeting.
Correct. That's also in our bylaws as well.
Okay. Scott, your mic's not on.
Yeah, so in our bylaws, it does mention the reconsideration at that meeting or the next meeting.
Okay.
Mr. Cruz, do you have a copy of the bylaws you can provide?
And while we're looking to that, and I don't know the staff you'd have to say as far as the notification of the parties, but as I recall, your client was at the meeting on March 24th, so was aware of the motion to reconsider. That's probably no substitute for a written notification, but he would have been aware of it at that time. So is there, what is the process for making notification prior to a meeting?
So because it was already discussed with the client at the meeting that would be coming up at the next meeting, there wasn't any official notice sent out. However, the petitioner's client or attorney was notified, or he knew about it, and he was in contact with the city. He was filling out a FOIA request for information, so they were well aware of this meeting.
Okay. So that puts us to the point where the board would have make a motion and have their discussion. So first I want to talk about a couple of points of confusion I think that took place at the original meeting. In my mind, one of them had to do with ownership, current owner versus previous owner versus the leasee, who I believe is the actual applicant, and who was doing what as far as regarding selling of vehicles and with what license, both city business license and state dealership license to do so. Another piece of confusion that I think that led to the reconsideration was the voting. And normally by our standards, we vote yes or no to the applicant's petition. When we heard this appeal, what we did was we voted yes or no to uphold the administrative decision as opposed to yes or no on the applicant's appeal. So what that ended up doing was we voted yes to uphold the administrative decision, which meant no to the appeal or no to the dealership, and we voted no to uphold, meaning that we were voting yes for the appeal and the dealership, which is kind of a backwards way of voting, which is not how we're going to do it. Today, we will vote on the appeal, yes to the appeal or no to the appeal, and yes meaning yes and no meaning no, as opposed to the reverse. So I think that added to some confusion. So in the process at this point, we would have to first entertain a motion on the appeal and a second, and then have board discussion. And with that discussion, board members, feel free to ask questions of the applicant or of staff. So we'll make sure we get the motion correct. So for clarity and understanding, I would entertain a motion approving the applicant's appeal to overturn the zoning administrator's zoning interpretation. Right, so at this point, before we actually officially go into discussion, so you know how the process works, it's motion is made and seconded, and then discussion takes place. So I would entertain a motion approving the applicant's appeal to overturn, and we'd have to put the number there, so to approve the request of AA 2201, the applicant's appeal to overturn the zoning administrator's zoning interpretation.
Mr. Chairman, I would make that motion.
I'll second.
Okay, so now it's time for our discussion. Does anyone have any questions or questions of staff or of applicant, or just discussion amongst ourselves?
I do. So I'm the one that.
All right, is your mic on?
Okay, so first of all, I'm looking at page 15, the timeline. And I noticed that, make sure I get this right here, looking at the dealership licenses. So in the, do you want to put that on the motorsport or not, I don't know. No. Okay, it says that M&S Motorsports had a license up to February of 2019. Right, 2019. And then after that, it says it was unpaid renewal. And it looks like Mr. Carter didn't buy the property until like, what, 3 or 4 months later? So during that time, because there was no license, does that mean that the guidelines go to the new rules, so it cannot be a dealership anymore? Or,
So my understanding is you're asking about the time from when John Cernovich, M&S Motorsports State DOT license expired and until property was purchased by Carter. Is that the time frame you're asking about?
Yes.
Yep. So that's correct. So during that time frame, there was no state license at all valid for that property. And that was, I'm trying to remember how many months that was.
that's from March. The one license expired in.
But I guess it doesn't, so from the emails that we've received from the state, they have never received an application from Alley Cats or Mr. Davis or anybody else to get another license there. They don't have Carter Auto Sales as having a state license there either. He has other licenses in the city, and they gave me all the details on those other licenses, but they do not have 1707 as a satellite or extension lot.
Okay, and then my other thing is that when I look at the licenses, page 72, 73, it goes from 2018, the license, to 2020, with nothing in 2019. Is that correct?
So that's correct, although I think I did learn some information so Carter, even though he doesn't own the property anymore, he can extend his existing city license. But the thing is, he never had a state license, so it hasn't ever been legally established on the property, even if the city issues a business license or a dealer license without the state also having a license, because he's not authorized to sell there unless the state approves that.
Okay.
And that's the crux of the situation, in that as when the zoning rules changed, if the use has continued, then it's continued to be grandfathered. And even though the new zoning laws don't support it, it's the continuation of that use means that it's grandfathered in and they continue to be a car dealership. But a break in that use means that now they have to follow the new zoning laws. So that's a good question, because that's really at the heart of the matter. I think from the testimony 2 meetings ago, when we first heard the case, I think it's very clear in my mind that the selling of cars, by the definition of sales that council read, the state's definition, that sales have continued on this property. I think that's clear. What I struggle with, and then to start discussion, what I struggle with is the fact that there wasn't a state-issued dealership license to do so at that property, which then means when we define whether or not the property was continued to be used as a dealership for our purposes, for zoning purposes, do we allow unlicensed use to equal use?
I have one more question for staff. So this property is in a flood zone. Are businesses allowed to operate in a floodplain, or were there things that were supposed to be done to make sure that it can go?
So I'm also the city's floodplain manager. I'm a certified floodplain manager. The way it works is you can operate a business in the floodplain, but there's specific rules that apply. In this case, John Cernovich, for his, when he owned the property, substantially improved the property. That meant that the whole property needed to be brought up to compliance with the flood damage prevention ordinance at the time. There's no evidence that that was completed. That would involve submitting an elevation certificate showing that information, which is why, one of the reasons why there was no final passing of the inspections and no certificate of occupancy for the building.
So even if this was, if they were allowed, if we say, yeah, you can sell cars there, they really couldn't, could they still sell cars because the property's not up to code or for the flood stuff?
Well, there's a couple different components to that question. There's the flood piece of it, which if they could do what they need to do to make that building compliant with the flood ordinance, that's one option, but you're not allowed to have a business that doesn't have an operable facility that's got a certificate of occupancy in it for restrooms. So that would be part of the component.
Yeah, that is correct. There was never a certificate of occupancy ever issued for this property after the change in use from the original gas station. And without that, you can't legally operate anything out of the business until you get that change of use approved. Since I do have the mic, I just would like to comment that I didn't remember notifying the applicant because it wasn't me, but 4 days after the meeting, Laura did email Attorney Malloy on March 28th.
Okay.
Chairman, may we have an opportunity to respond to some of the staff comments here?
Well, that would take a question from the board member. So if a board member does have a question along those same lines to the applicant, we can.
I would like, Mr. Chairman, I'd like to have the applicant tell us what he wants to say about this process. And
So Angela, that was your question. Do you want?
Me? No, I was, sorry. So, Mr. Malloy, when you presented your case, you also had some licenses that you shared with us. Are they the same as what we have here in the packet, or do you have something from 2019?
I don't know exactly what you have in front of you, Madam Chairman. Maybe you can show us what you're talking about, so there's clear.
So I think you had some of these.
Yes.
So this was, I guess I'm not talking to the mic. So this one was the 2018 that expired. And then there's nothing until 2020. And I don't see, I know you showed us some of those. And like these are not paid, so I don't know if those are the same that you shared with us or not.
Those
In
were
your
actually
packet.
submitted by Attorney Malloy at the last meeting.
Oh, those? Oh,
Yeah.
okay.
Also on page 71 is everything he submitted at the meeting, which is those exhibits 1 through 11. That's also what he submitted as part of his application as well.
Okay. So the one from 2020 was never paid. It says zero, so. Okay.
First of all, I just want to comment on Mr. Coop's statement that filing a FOIA request is notification for a board meeting. I disagree with that.
Point of order.
I think that
That was not the FOIA request, Mr. Malloy.
May I finish, please? You want to interrupt me when I come up? I didn't interrupt you when you were talking to the board. A FOIA request does not constitute any kind of notification by the city of Davenport on this meeting. There was no notification sent out regarding this meeting, specifically on the motion to reconsider by the city of Davenport. Secondly, we did submit those business licenses. I do not believe we had the 2019. And I'm going to let John Davis address this further. Those are the ones that we were able to locate in our files, in my client's files. So there was not a actual 2019 business license submitted from us, but that does not mean there is not a 2019 business license. I would request that the city respond to that by stating for the record whether or not the finance department issued a 2019 business license to the applicant at that time, or they did not, for the record. Further, I think there was some confusion on the boards regarding the issue of the state approving the business license for the used car business versus the actual zoning of the license, zoning of the property. And we have been in contact with the state of Iowa program administrator, Kevin Cruz, regarding this particular issue, an attempt to clarify that. And I'd like to have my client pass out 2 letters that I received dated April 11th and April 14th, 2022 from the Iowa DOT.
Yes, so,
Dealer Program Manager Kevin
excuse me,
Cruz.
so first of all, you're beyond what the question was, but that's okay, because I'm going to ask the question that's going to let you finish this, because that's where I wanted to go. So at the heart of the matter, of whether or not the non-conforming use has continued, in my mind, is whether or not this property has been a legal car dealership throughout this period in question. The state has provided evidence that says that there's not been a dealership license for this piece of property for a period of time. That would then say that the non-conforming use had halted. So my question to you is, since the state has provided evidence saying that there wasn't, do you have some information contrary to that can show that not only was someone selling a car there, right, by definition, we've all sold cars, that doesn't make our driveway a car dealership, but from a legal standpoint, has there been a legal continued use, licensed use as a car dealership at this address?
I'm going to let, I'd like to request to have John Davis address this question directly to the board regarding your issue. And I want to clarify one thing. When you say the state has not shown that, I'm going to specifically, are you talking about Mr. Kevin Cruz? Or are you talking about,
I
I
don't have the state, but the staff asked the state about dealership license and that there was no dealership license for a period of time.
Okay, John, do you want to address that?
Yes. You guys are regarding John Davis, River Drive, I was those. Eric Carter's license, the state dealership license, and the city license. You stated he could not have the car lot because it was never issued a state license. You look at the paper I gave you guys on the second one, and it states right here that is not required to have a compliance. A dealer must reply an extension lot is licensed, lot is approved, and the DOT issues license for the extension. The lot is under the dealer's numbers, principal place business. Separate full dealer's license with separate dealer number is not required. He's not required to have a state license because he runs off his primary license on a sublot, extension lot. That's why there is no state license. This is from the state of Iowa DOT.
But the extension lot would have to be annotated.
It states right here that it does not have to be. And it does not, I mean, that's why there is not one. He runs off the same dealer's license number, the same dealer plate, the same insurance, the same bond. And they have a letter stated here on the other one showing that. Now, what you guys are getting very confused, I think, on the question, a dealer's license to have a dealership has to have a primary dealership. Derek was not using this or Derek Carter was not using this as a primary dealership. He had a primary dealership. And it states right here, you do not have to have a second license to have a lot. And that's the answer to the question everybody's been asking since the last meeting. I had to do a lot of digging to get the actual answer. I had to get hold of the state. His license to the city to display a motor vehicle is up to date and in code. The letter we got from Matt Flynn, which he had to give the state, the letter from Matt Flynn, that went to them to give him the extension license. He had to get that approval, zoning approval, before he can get an extension license. What you did, City of Davenport gave him one, which you guys have copies of.
But it says a dealer must apply for an extension lot license.
And he did that. That's how he has that. That's sitting right there in front of you guys. It says overfull lot that she just passed around. That's from the City of Davenport. The state does not issue that. That's from the city.
Right. but
Right,
when you
not
look at
the
those-
state.
I'm sorry. When you look at those papers, though, it says that it's not been paid. It says
Because
zero.
it's zero because he has a dealership already, so he doesn't have to pay for that license.
Would
That's why it
staff be
says-
able to look at the letters, please?
Huh?
Can we look at what you handed out?
Yes, I ran out of copies.
Here, I'll give you.
I got a couple right here. That's why I came over.
The original question was about the state dealership license, and now
Yeah, that's what
you've
I'm
shifted to
answering.
talking about the city.
I'm not,
dealership
I'm answering your
license.
question about the state dealer's license, Iowa DOT. That's the answer to your question. There has not been a state license at 1703. It's not required. It states right there.
I'm sorry, I guess I'm having problems with 2B, because it says a dealer must apply for extension lot license. Once extension lot application is approved, the Iowa DOT issues a license for the extension lot under the dealer's license,
Yes, and he has that under his dealer's
under the
license.
dealer's license number of the principal place, but there would still be something issued for the extension lot.
It's on his main primary license. That is his main primary license. It's on there. It's not required to have anything for this address down here. They don't issue anything for it. You say
Okay.
anything,
It says the DOT issues a license for the extension lot.
it's added onto his primary license.
So the primary license lists this address.
Could I help with
No,
that?
its address will not be listed at all. 1703 will not be listed.
Yes, please.
Then I don't know how that's saying that there is a license for an extension lot if you're saying that the license doesn't say where the extension lot is. It's not annotated anywhere.
I don't make that rule. I'm just, letters I got from
Okay. So, all right, thank you.
Kevin Cruz. And this is what letters he sent back. He's not required to have it. He's required to get a zoning letter, which he went through Mike Flynn to get.
And so these
And we
are,
have the city license for the,
right, I
yes.
understand the city license. So, to staff, thank you. And this to me reads, this is the general rules, but specifically, and you can adjust the rules as they've distributed, but specifically, the city has asked the state if there was an approved license for this piece of property, and the answer was no. So can you help deconflict the two?
So, go ahead.
That was for staff, yeah.
Well, the chair is correctly interpreting paragraph B of this April 14th letter signed by Kevin Cruz. The extension lot has to be annotated, noted somewhere. If it's noted on the primary license, that's fine, but it's got to be noted. Otherwise, the state would have no way of tracking these things. Fact is, there was no notation of an extension lot for 1707 West River Drive from the state of Iowa, so it was never lawful as a location.
And that's found on page 29, our email from the state, Erica Eckstein. She showed 1, 2, 3, 4, 5 bulleted points that list all of Carter's licenses in the city, primary and extension, and there's nothing on there regarding 1707 West River Drive whatsoever. So there is no extension for that property. They don't have any documentation showing that.
I mean, I have Derek's state license. I have the city license.
I have a quick question.
Okay.
We keep going back to Carter Auto Sales. And from what I can understand, Carter Auto Sales hasn't owned this property in, what, over a year and a half?
Probably going on, well, it's probably about
So-
going on a year, yeah.
So wouldn't, if he had license, wouldn't that be, if he doesn't own the property anymore, correct me if I'm wrong, but does his license even come into play here?
Well, it does because we're trying to fight for the non-legal conformance use of the lot. We have 12 months to reuse it.
No, I understand what you're saying, but you're already over the 12 months.
Derek
because-
is still using the lot as of now. His license
Who's
is still
Derek?
good. Derek Carter, Carter's Auto Sales is still using property.
He still uses the lot
Yes.
even though he does not own it
Correct.
correctly.
So if I can ask a legal question of counsel, so when a property is sold, does the new owner have to apply for the license?
Well, somebody could lease the property without owning it
Right.
and be entitled to run a business from it, which is what they're saying is
So-
happening.
Okay. But I don't think the original owner, once he sold it, leased the property from the new owner.
I don't know if that was a question or you were thinking out loud.
Well, I'm thinking out loud, as I understand the change of hands of the property, went from the original owner, Carter Auto Sales, to the existing owner, and then the existing owner has leased it to the applicant, but the existing owner hasn't leased it back to the original owner, which was Carter, that has the license.
Yes, he still has a standing lease with the property owners until I have my license figured out.
We have not been provided with any evidence of leases.
That was a verbal contract, and we stated that with Derek Carter on the last meeting. It's on record.
Mr. Chairman? I don't mean to
Yeah,
get
go
off
ahead.
the subject, but I'd like to ask a question.
Yeah, go ahead.
You know, it was brought up during Mr. Malloy's presentation and the people that were applying for this license. You know, I heard a comment that the state inspected that property,
Correct.
and and this was done, obviously, when they probably inspect Carter's on Rockingham, they go down to the other location at 17. So the state was involved with this, with the inspection process.
Right.
And did you get any correspondence from them that it passed, or
It's so that they told us we passed everything with the zoning
was this
letter.
verbal or was this in
No,
written?
Matt Deanbot did the inspection. He's an on-site investigator for the DOT. He works with the Kimberly DOT. He did the inspection and he sent that off to Iowa Department. When they said they don't have a application on file for 1703 West River Drive, they have Alley Cats LLC listed and Barrick LLC. They have nothing to do with this. This is River Drive Auto LLC. So if they look up the right name, which we've been stating.
Again, I'm asking, the state's involved with this,
Yes,
and they inspected the property
correct,
and said it's fine as a car dealership.
correct.
Some, I'm getting my words mixed up. Some outlet or.
It passes for all of it. Car dealership, a sublot, an extension lot, it passes
Okay,
everything.
so they're well aware of that property, the car dealership.
Yes.
Okay. Thanks, Mr. Chairman.
I mean, I wouldn't be standing here fighting if I still had to get the state's approval, spending a ton of money on attorneys. I'd be fighting with the state. I'm fighting for a zoning letter that we are definitely grandfathered in. It's all black and white.
So I guess this isn't a question, you can have a seat.
Okay.
Unless someone else has a question, but for my just our discussion on page 29 of the packet, which is page 3 of an email regarding the property at 1707 West River Drive. The state lists the dealerships related to Derek Carter and all the extension lots by address, so clearly they're annotated. And the 1707 West River Drive is not one of those, and the state says, in a very brief sentence, that there is no current license at that location, or at this location, to quote them. So they don't have that, they don't have records of that address being covered by any state-issued dealer license.
If you look down here, John Davis again, River Drive, it says he voluntarily surrendered his license. The reason why 1703 is not on there, because he found out he did not need it. So he voluntarily surrendered it. It states right there on your page you're looking at. He did not need the state license for the property on his other one, so he voluntarily surrendered that one because it's an extra charge. Why pay a bunch of money for dealer place insurance if you don't need it? That's how we know he did not need it for 1703. And it still says effective and active, voluntarily surrendered. Effective.
Staff, I don't see, I see where he's looking at, but I don't see that.
I don't see that
Address
either.
listed. I mean, I see where he surrendered, it said
Yeah,
extension lot on Rockingham Road.
He surrendered it. That's why he never applied for it for River Drive, because he did not need it. He surrendered these ones because he did not need it. Like I showed you this paper, it shows you don't need it. It's not a requirement. If you have a primary license, it's not a requirement.
Oh, but they even note the extension lot voluntarily surrendered. Extension lot voluntarily surrendered. So the extension lots are still annotated and are still licensed under the primary license.
Correct. Extension lot, and his license is actually a sublot license. It's not even an extension license that we have for the city. That just displays a motor vehicle for sale. Extension license allows you to test drives, make a deal, add the lot. A sub-license allows you to display a motor vehicle. And there's a bunch of different licenses that it's getting very confusing. But none of them are a requirement if you have a primary license.
Okay, I'll keep going back to where they say there is no license at that
And
location.
we keep going back to that point. There's no license because there's not one required. The only license they have is a city license that Matt Flynn signed off on. And the city gave a license for a license.
Mr.
For
Davis,
3
it
years
might
at
be
this point now.
helpful.
Why even make this a matter after 3 years? Why want to take a license away after 3? Why did you renew it for 3 years?
Are you able to point the board to a code section that says that? That might be helpful.
Can I just walk up and show you what I don't know.
I have it right here. I know what you're talking about.
Okay, so I don't know where I'm getting confused. I don't fight for attorneys.
What I was suggesting is, I know you're saying that he's not required to have a license. Do you have something somewhere that states that?
On this, well, can I just walk around and show you guys? It'd be easier.
I would prefer you to stay at the podium
Okay.
and point.
All right, you have
Which letter you gave us?
B. It'd be B. The second one of B.
The 11 April or
ABC.
14 April?
Yeah, number 2, B.
11 April or 14 April?
This would be 14.
Okay. 2B.
Yeah, number 2B.
I guess my thing is, I don't see where the extension was ever approved.
Right. I mean, 2B says
Yeah.
that they'll issue a license for the extension lot under the dealer's license number. But there's not a license issued for the extension lot under that dealer's license number.
Not a, we have a city license that's what Derek Carter's also spot with Matt Flynn over. He had to send that off to the DOT, and then he had to get a city license through the city, which we have, it's not a requirement for him to have a state license. It says it. I mean, he just had to make sure the zoning was correct. That's all they need to do. He sent an email and the zoning was correct, and he was able to post his cars there.
Okay.
I'd like to go back to the timeline again, where it says that for the dealer license is an unpaid renewal from March of 2019, and then it doesn't show any other payment, and it shows Carter Auto Sales in 2020 was issued in error, but it doesn't show I don't see any evidence of anything that was paid in 2019.
Well, it would be his. I don't know why they put zero, because they don't charge him. That would be a question that that's the city. When he has a license, I have no reason or recommendations why it says zero.
Okay.
It doesn't show an expiration. It shows an expiration date on 2020. It's still active as of now. And you have 12 months to renew your license before anything, takes place anyways. But why it says $0, they don't charge you. Yeah, as far as I know, they don't charge you for a license if you're doing an extension lot or something off your primary license. They charge it on your primary license, your city license.
Staff, when I look at the other business licenses issued in 2018, it says they were paid $100, so.
2018 is a primary lot through M&S. That Derek Carter's primary lot would, if you look at his license for his primary lot, I think his address is 2647, 2637 Rockingham Road. That one will have a charge.
We don't have that.
Mr. Davis is correct that the M&S Motorsports was a primary lot, and that would have had to charge $100. However, the business license that's in here is actually for Carter Auto Sales at 2637. It should show amount paid, and there's an annotation that it's a sublot. They would not be charged extra for the sublot, but it does not show an amount paid for the entire license. And then there's not a date issue on it either.
Okay. Tom, you have a question?
Yeah, I guess a comment and a question that's been kind of bothering me for a while was thinking back 2 meetings ago, in my opinion anyway, I thought it had been reasonably established that a dealership had operated continuously throughout that time. And I believe there was also a valid City of Davenport permit or license or something. And I remember coming away from that thinking, well, there may or may not have been a state license issue. And I guess what bothers me is, and maybe this might be a question for staff, might be, as a zoning board, should we be sitting here debating the legality of the business? I mean, is that really our place? I mean, I'm looking at it from strictly a zoning issue. Is it our jurisdiction to say that, should we be debating this issue at all? That's what's bothering me, I guess.
Well, I think their case is based on whether or not a lawful non-conforming use existed there prior to the change in the zoning. So that's where the lawfulness comes in.
I feel like that term lawful got added since that last meeting.
Well, I mean, you could have an unlawful use of a property that doesn't give you a legal right to continue it. So in order to have a grandfathered use of the property prior to the change in zoning, it would have to have been lawful.
It seems like it was half lawful because like the city issued a permit or a license, but the state didn't. And I know he needs the zoning board approval to get his state license. So this is really a complicated.
Okay, well,
It really is.
He needs a city business license in order to get the state dealership license. And I did bring up in a meeting 2 meetings ago when we heard this, I think it was a question to it was a response to Mr. Malloy's question or comment about the dealership license. And to me, having a dealership license was a vehicle that, no pun intended, a vehicle that I would use to say whether or not it's been used as a dealership. Because with a dealership license, one could say it's being used as a dealership. And without a dealership license, I have a hard time saying that a licensed use, I won't use the word legal, but the licensed use of the property has been continuous. So that's why I think this, the whole issue of the state dealership license is a way of demonstrating whether or not it has indeed been a dealership continuously through the period. So, Mr. Warren, I have a question for you, because it was said that it's not required to have an extension license. But from what I read in 2B and from what I see in the exhibit where they actually list the addresses of all the extension lots, can you help me understand the extension lot issuance of a dealer license extension lot issuance?
So what the state calls an extension lot, the city calls a sublot. All right. So if you'll recall, back on March 10th, I made some references to Iowa Code Section 322. So Iowa Code Chapter 322 is the dealership licensing provisions in the state code. Iowa Code Section 322.3 is entitled Prohibited Acts. 322.3 sub 2 says a person other than a licensed dealer in new motor vehicles, so somebody who sells only used motor vehicles, shall not engage in the state in the business of selling at retail used motor vehicles or represent or advertise that the person is engaged or intends to engage in such business in this state unless and until the department has licensed the person as a used motor vehicle dealer in the state and has listed the premises, small print, and has issued to the person a license in writing and as provided in this chapter. And I gave you the definition of selling in chapter 322, which includes bartering, exchanging, delivering, and otherwise dealing in. So for this property to be licensed by the state, they would have needed an extension license noted on the license. The state of Iowa has told us that didn't exist. Derek Carter told us he never had one. He didn't need one. The state law says otherwise. 2B in the letter from Kevin Cruz says otherwise.
So even though the extension lot would be listed under the dealer's primary number, there's still a tracking mechanism for that extension lot under the dealership number, regardless of where their main lot is.
Correct. Where otherwise
Which is
the
what
state
is-
would have no idea.
Right, which is the examples on page 29 that lists the different extension lots by address.
Correct.
It was the city license and the city zoning letter as it states in here that we had to send, that Derek Carter had
Can you
to
speak up a
send.
little bit?
It was the city license and the city zoning letter that Derek Carter, Carter's Auto Sales, had to send in order for them to be able to legally sell cars. He sent that email to them from Matt Flynn stating it, and he also had sent him his city license. They are not required to give him nothing back for it. I mean, if they've been showing cars, and this has been a dealer's ship for years, going on 3 years now, Derek has renewed the same license, mind you, and they have not, why would they not take it from him 3 years ago? Why would the city even issue him a license if it's not right? And I had personally went up and talked to, what's her name again? Laura, sorry. I personally went and talked to Laura. She had asked me to go down and get the city license, stating that Derek Carter, Carter's Auto Sales, had a license down here at River Drive Auto Sales, and that she would approve my zoning letter. I did that, and that's why you do not have a 2019 from me. So I got the 2018 from M&S Motorsports, and the 12 months prior to that, which I was required to show her at the time, she said, proving that Derek Carter, Carter's Auto Sales was operating out of there. I showed her those, and she said I was good to go. I took every single other step through the state, had the lot inspected from the state, passed everything I needed, recontacted her, still waiting for the zoning letter, and we got denied for it.
Okay, Laura, can you help me understand a little bit of difference between the city business license and the state dealership license
So
and the order thereof?
the city business license does not mean you can legally, according to state, sell, barter, or any kind of card. You still have to have the state. So even Matt's letter, which stated that it was grandfathered in, which I personally do not agree it was. There's no to me evidence that M&S Motorsports, it was ever established, ever sold vehicles there. They didn't have a certificate of occupancy to occupy that building. But that aside, after Matt Flynn wrote that letter, he never got the state license associated with it. So whether or not that there is a city license out there doesn't really matter, because you cannot legally do a use on that property per state code. So there would be no grandfathering at that point, as the use was not legally continued.
Okay.
If the use was not legally continued, why did you guys renew the use 3 years in a row?
You're not to directly talk to staff.
No, I just did a second ago, and it's okay.
Yep.
I'm sorry.
So I think the city can license you to do business, but whether or not you have additional requirements, whether it's, in this case, the State Department of Transportation or public health requirements or any other requirements, having a license to do business on that property doesn't negate any of the other requirements.
You're correct. That's what I'm here for, is just a zoning letter from the zoning board. I mean, that's all I'm asking for. I'm not asking you guys to give me a license. I'm not asking you guys to open up my doors and say, you can run a business. I just want the zoning letter that I feel I'm entitled to. I feel like everything I've showed you guys has been right in order in all their standings. Every time we say a question, it gets spun around in a 360 and answered a different way. They are correct on a lot of the stuff they say, but I'm looking at it wrong. A primary dealership, yes, you have to have a primary dealership license. You have to have a state license to have that. This is not a primary dealership. The property itself was just being used to display motor vehicles. It's just a zoning question. We just need a zoning letter that states that we can legally display a motor vehicle. I'm not asking you guys for a state license. I'm asking you guys for dealership or car insurance or credit check or nothing. I just need a zoning letter that I was told I can get before I even signed a lease with the building. I was told every, 3 years, and Derek Carter's title sales has got the same license I'm asking you guys for. I'm not even asking you guys for a license. I'm just asking for the zoning letter.
Bridget?
If I understand correctly, you basically need to prove that car sales were happening in this time period, whether there was a license or not.
Correct.
Every single one of the pictures I'm looking at that were in this packet, it doesn't look like a car dealership.
A lot of these pictures.
There's all the way back to 2008.
Yes, a lot of these pictures go back so far, I don't even know who owned the building.
And there's up to 2021 or
We have quite a few
2022,
here that have
and there is
cars.
no vehicles on this lot. So from the pictures that we have been given, it doesn't look like any kind of a car dealer lot.
We addressed that last meeting, and we showed proof. A lot of their pictures are taken above head after 2018. They're all sitting underneath the canopy. Even as if you drive down there right now, you'll find vehicles underneath that canopy. You cannot see.
There's
them.
one right here from 2020, and it still had graffiti on it.
Correct, but they're
So
not-
you're selling cars on a
No,
lot with
that-
graffiti on it?
They
Yeah,
know
that
they
one.
graffitied it, and Derek removed most of the vehicles from that lot, but there's still cars under the canopy on that date. That's the building itself. They're not underneath the canopy. It's not, you can't even see the canopy from there. They're taking pictures where the cars are not.
But you can in the picture below it.
Right, in the picture below it, you can't, there's
And what day
no
was that picture
car
for?
dealer, no sign, no,
So the top left
We're
is-
going after 2019
Here,
pictures.
just to help everybody, since it's so small, I'll read it for you. Top left is from July of 2021. Top right is, it is November of 2020. Bottom left is August of 2019, and bottom right is December of 2018. And then this is, this one's March of 2017.
Right after graffiti's when Derek decided to sell the lot and he moved everything off of the lot. Then we
okay,
came
so
to
you
the-
just said he moved everything off the lot.
Correct.
So then it's not a,
We made a deal with Derek and bought the property from him, and then I released him the parking lot back. All within less than 12 months, all within a month. You know, everything got graffitied, a bunch of his Cadillac converters got stolen. They went down there, they
understand
moved
that.
everything out of there. City came down, took pictures of the graffiti. They had even had a talk with the city, what was going on. They were all informed about that at that time.
Let me get this straight. So you are the owner of the property?
I am going to lease the property from River Drive House, that's correct.
Well, this is really none of my business, but I'm gonna go ahead and say, based on all the problems that Derek had at this location, do you really want to invest your money here?
I agree with her. Do you see what that building looked like when Derek had it compared to what it looked like when we had it? I painted that building. I have put a lot of sweat, hard work. I've had my 8 kids down there raking every leaf off that property. That place looked like a shithole when Derek Carter had it. It looks like a totally different place. The windows are tinted, it's painted, it's nice. Everything inside is just, I took home.
Okay,
Did everything I could. You've seen Derek's other businesses, you'd be like, wow, why haven't I shut it down anyways? I'm not Derek Carter. I'm not really affiliated with Derek Carter.
Okay. Any other questions? All right, thank you.
I have one.
Okay.
Sorry. Do you, forgive me if I don't know the number of the page that your current pictures are on. I know you gave us some, the building's painted blue, and so I know those are here, but I can't find them currently. 87?
If that's the one that you're looking for. Are you looking for the ones submitted by the petitioner?
Yes.
Yeah, they start on page 87.
So when I'm looking at page 87, the picture at the top, there's one car in the lot. One.
Yes, that is, yes. That's the guy that was taking the photos.
Okay, so there's one car in the lot, and that's the guy taking the
No, if you
photos.
look
So that's
under-
not,
If you look underneath it, that's kind of what we're approving. There's
Right.
3 cars there on that day you cannot see from the sky.
okay, I see that,
Yep.
the second picture.
And there's 2 that sit inside the building.
But I also see that those cars don't have any kind of sticker or anything on them that would say they're for sale.
They all have prices and dates on the back of the window, back left corner, upper top.
Forgive me for saying this, but anybody could have just driven their car under there and taken a picture of it.
Correct, I'm not,
So, I mean, I will agree, yes, you did update the building, paint it, clean it up, I get
I'm
that.
not here because I'm trying to trick you guys out. If I didn't think the state was right, I wouldn't even be here. I'm not here for the state, I'm here for the city. I'm here because Laura told me when I first looked at this property, I can get a dealer's license from it if I can prove to her Carter's Auto Sales had a business license out of that place for the last 12 months. That's how I have the copies I gave to you.
And that's what instigated my whole zoning interpretation. So I did my due diligence and research on it.
And if the city, you know, they say it shouldn't have been a car lot for 3 years, they re-licensed the same person for 3 years, why didn't they cancel it 3 years ago? So there's some kind of discrimination or something, I'm not sure, you know, because whatever reason, that's what I'm being discriminated against. I have everything here black and white, everything by law, everything the city's asked me to do, everything the state's asked me to do. Now we are months later, tons of money out for all kinds of fixing the place up, attorney fees, and I'm not asking you guys for, if you guys give me a zoning letter and the state says, no, you can't have a license there because whatever reason, your building's blue, that's not your guys' fault, and I'm screwed.
Any other questions? All right, thank you.
Thank you.
So I guess the one, my final discussion point, I keep going back to the authority, the state of record for DOT. In February of this year states that there's no license, so if there hasn't been a continued non-conforming use, then we can't continue, the use. It's not grandfathered in. And that's the way I interpret that. Is there any other discussion? If not,
Yeah,
go ahead.
I originally had voted, with the applicant, but now that I look back at all the evidence and stuff, I don't really see any evidence of the license being paid. And I agree with you about that it was illegal, and so I can't grant the request. So.
Anything else? I'll just go down the row.
No, I mean, just going back to, 2 meetings ago, I don't think anything I heard tonight really changes my mind. I think that it's been reasonably established that a car dealership has been in continuous use since then. I don't know that, there may or may not be a state license issue. I don't know that that's our purview. So it's a tough one, but I think I would tend to stick with my original vote.
All right, Bridge, anything else? Jim?
Yeah, Mr. Chairman, I grew up down the West End, and businesses are tough down there. And, I went by that location probably every day and seeing how deteriorated it was. I've seen cars in there, I've seen cars not there. But here lately, in the last 6-7 months, the building has been painted and there's cars there. And I don't want to lose a business down the West End because it's really tough to get people to come down there. And I'm just speaking from my personal view. And what my main thing was that the state was involved in this. They went down to inspect the property. So if there was no license, why did they go down to inspect it? They have to make reports what they see, and so something happened there that they're well aware that this was a used car lot, and I voted for them, and I'm going to do it again. And we can't lose a business by who's at fault of this? Is it the city? Is it us? So I'm going to vote on the side of error that I want to make it right, that this business is good for the city down there. And so that's my final thoughts.
I would concur with that, Jim. I mean, I would, applaud the applicant for,
Right.
establishing a business in an otherwise blighted part of town.
Right.
And, I can't say enough that that's something I probably wouldn't do, but Mr. Davis certainly has got more courage than I do, and, I applaud that very much so. So, he may or may not get his state license if we grant the zoning a letter anyway, but, I think in my mind, I would be willing to grant that zoning letter.
Well, Tom, it's just that if the state wasn't involved, what concerns me is the inspector went down there and inspected the property. So the state was involved in that. So I don't know if he just didn't want to do any reports on it. I don't know. But again, I think it would be a great business down there, and I think that he would keep the place clean, and we need that. Thank you, Mr. Chairman.
Thank you. I agree that, the state inspected. Now, that doesn't necessarily mean that they issued a license, right? Because you'd have to inspect first. So our charge, and Jim used to read this every meeting, and I guess I read a different preamble, but is that we hear and resolve cases applying the strict application of zoning laws. So the city zoning laws are that between the new zoning laws and the old zoning laws is that there has to be grandfathered, continuous non-conforming use. I think is the language or something real close to that. So continued non-conforming use, and it can be grandfathered through. So that's the strict application of the city's zoning laws, and that's what we're charged with. So then how do we define whether there's been the continuation of non-conforming use. So therefore, has there been cars continuously sold there? And that's the question. And so then it comes down to, I think what I put in my my amendment to the minutes, and is can we allow non-licensed illegal use to define use? And that's something we had to have in our own mind where we're at with that. So how do we define in each of our own minds what is, continued non-conforming use of this property as a dealership? So we've all heard the evidence of the of what's been done there and by whom. So in each of your own minds, we'll vote to say whether or not we believe there's been continued non-conforming use given the strict application of zoning laws. So if there's no more discussion, I want to be real clear on the voting. Because again, the last time we voted backwards, last time we were voting for or against the letter, and what we should be doing is voting for or against the applicant's petition. And that's what the motion was. So the motion was to, I guess, can we go back and read the motion, Laura? Or Scott?
Just made a motion approving the applicant's appeal to overturn, but you included the AAA number in that. So it was a motion approving the applicant's appeal.
Okay. So if we approve the applicant's appeal, and the appeal was to overturn the letter, so voting yes to the applicant's appeal means we overturn the letter, therefore it's a yes to the dealership. So a yes vote is in favor of the applicant, which again is backwards from last time. So a no vote means no, we don't accept their appeal, therefore we do accept the interpretation letter, therefore there is no dealership. So boils down to yes, you're in favor of dealership, no, you're not in favor of the dealership, according to the zoning laws. So if that's it, then we need a roll call vote. Tom? Oh, okay, you're just gonna write. So we're all tracking, that's the right? Okay, so then we need a roll call vote. Yes for the dealership, yes for the appeal, no, not for the appeal, no, not for the dealership.
Wait, Carlson, sorry.
Yes.
Quinn?
Yes.
Laybach?
No.
Rice-Dropper?
Yes.
And Darland?
No.
So that's three, that's in favor of the applicant.
That's in favor of the applicant, 3-2 in favor of the applicant. And there is,
Laura, I'm sorry, Mr.
yeah, go ahead.
Laura, now, the applicants will not have to come back here again in the future.
So the next meeting, you guys need to ratify the minutes.
Okay.
I'm really hopeful that you guys aren't reconsidering again, and we can move on. Okay?
Yeah, we move on. Yes. Okay. Thank you.
Thank you.
Thank you, Mr. Chairman.
All right, so there's no other business, then I will entertain a motion to adjourn.
Thank you, everyone. Make a motion to adjourn.
Second.
All in favor?
Aye.
Against? Thank you.